I realize we are very much behind and we all want to get home or get to dinner or whatever it is that we need to get to. So I'll be very brief. I'm going to give a quick English introduction to PILs, which most of you are familiar with, especially after today. And then Advocate Roy will then really explain and expound upon it since he is an advocate. India is known worldwide as sort of the birth of the PIL, and known for its great successes in harnessing the power of the legal system to promote human rights or promote issues in a human rights framework. In fact, the first PIL was filed in India in the 1980s by a petitioner named Sunil Batra, who was a prisoner. He filed a PIL and complained about inhumane treatment, and that has sort of been the watermark of PIL work in India. And since then, PILs have proved really powerful methods of promoting change, especially in fundamental rights issues, including torture and prisoner rights, as the first PIL showed, police harassment, atrocities committed against women, etc. And from today's sessions, you can see that there's a lot of uncharted territory in terms of the issues that we can litigate before the High Court and the Supreme Court here in India, including sexual health education in schools, access to contraception. We'll be talking about hysterectomies tomorrow morning. So there are a lot of issues that we can still talk about, including child marriage that we haven't yet, and that could prove really fruitful and successful. Let's see. So, although the Supreme Court has received some criticism for being, quote-unquote, an activist sort of agency, the court is really working at making sure that laws are being implemented, and not only laws, but state level and national level schemes, judgments that have been passed previously that are left sort of unused after they've been issued in an order. So this is a collaborative effort. It isn't just the judicial system here in India, but policymakers and activists and advocates like ourselves who can then promote human rights through PILs and which stands for public interest litigation, and SLPs, which are used before the Supreme Court here in India. Some basics just to sort of dispel. You think of a PIL and you just think of a lot of work, or maybe it's just a really big endeavor, but really it's very basic and very easy to implement, as Colin was saying this morning. The biggest issue is sometimes finding a petitioner, and you think perhaps you have to be the victim, and then you have to go into the court, and it can be very daunting and intimidating to get up there and say what is going on and why you're a victim. But the truth is that anybody can be a petitioner. It just has to be somebody that's not self-interested or self-motivated. In fact, the rule is that the credentials, motives, and the objective of the petitioner have to be apparently and patently above board, meaning you have to be doing this for, out of the kindness of your heart, really, for somebody else's sake. So it doesn't have to be that you initiate and do all the work for it and then have to represent your case before the court. You have a lot of help, including HRLN, people who are there to finesse your petition, to help you with fact findings, to help you get your representations to the government, to then help you argue the case before the court. You have a really big support system, and it's just a matter of getting somebody to come and approach HRLN or any advocate, really, and then get this thing in the High Court and the Supreme Court. Let's see. So the parts of a PIL, just again to dispel any idea of a PIL being a very big issue or a very big endeavor. The parts of it, just to break it down, there's a synopsis, which is just a brief introduction to what it is that you're arguing, what issue you're bringing before the court. A list of dates, which is really your story broken down into very digestible, sort of line-by-line items so that the judges on the court, because the judges see a million matters a day, so if you can just break it down for them, it makes it a lot easier. The actual petition, the grounds, which is the remedy that you're seeking, if it's an interim order, if it's some sort of punishment against the wrongdoer, what have you, and then the annexures, which are your supporting documents. And the way that you get all these things together, if you're an activist in the field, is You go out and you see what is wrong in your community, in your district, in your state, in your geographical region, in your backyard. You go out, you talk to people, you get their dates, their names, the dates of when you talk to them, take pictures, talk to as many people as possible, and then put that all together in a report. And just, dot your I's and cross your T's in terms of who you've talked to, when you talk to them, what the issue is. Very, very simple and doesn't take a lot of your time. I've gone out on some fact findings. In fact, I went to Barbani. I know somebody else was talking about it today, and I did a 2-week fact finding where I went into PHCs, CHCs, and sub-centers and district hospitals and just talked to women. And they are more than willing to talk to you, most of them. Not the doctors so much, but the women who are there are more than willing to tell you their stories. After you do that, you make some representations to the government. You write them letters. You say, this is the issue in my community, and this is what needs to be done, and can you do it? And you wait to hear back from them, and if they don't hear back, you keep note of that, and you gather all of these documents and put it together with the report that you've already written, or the notes that you have put together. Then you get all of this information, and you take it to an advocate, or you bring it to somebody at HRLN. You can bring it to me. I'm not an advocate. But I'm more than happy to take that information and then help you put it together into a petition and hope, connect you with an advocate who can do the same. And then we go from there. Like I said, it's a very collaborative effort, and you don't have to do it by yourself. And then what the advocate does, what we bring to the table is we help come up with the prayers. What are you asking from the government? And how can we get it? What's the easiest way? What's the best way? What will have the biggest impact? And then we argue it before the court. And sometimes it's easy to lose sight of the fact that you bring one case and then maybe it changes your reality, but then you have to remember that sometimes orders come in and they change the reality of hundreds of thousands of people. And sometimes that's lost in the whole thought process of filing a PIL and how troublesome it can be. And some things to remember is that it's a very long process, or it can be a very long process, a very difficult process. The legal system in India is not the easiest to navigate, and sometimes you feel like you don't have a lot of help, but we are all here to help and to support you through the years of however many years of litigation we have. And finally, I will close by saying that although the law isn't, the end-all to all of these problems, it is a really powerful tool, and we have to be able to use it in conjunction with policy, and in conjunction with activism in the field and policy with your lawmakers and politicians. And we hope that after today and after tomorrow and in the future, you will think of HRLN as a partner in promoting these human rights issues that we have highlighted today and any others that you might bring to the table. We're more than happy to work with you. Thank you.
साथियों, कल दिन भर या रात भर की यात्रा और आज दिन भर के भाष मुहावसे के बाद जो आपके चेहरे पर थकान दिख रही है, उसमें मुझे बहुत ज़्यादा बोल कर आपको कष्ट देने का काम नहीं करना है। संक्षेप में आपने बात सुना। जनहित याचिका एक अभियान के तौर पर एक लंबा सफर तय किया है, और ये याचिका का ऐसा स्वरूप है जिसकी शुरुआत वकीलों ने नहीं किया। ये बहुत ध्यान देने वाली बात है कि जो पीड़ित जन समुदाय उनके अंदर प्रतिरोध की जरा सी भी इच्छा जहां जागृत हुई और उन्होंने संसदीय जनतंत्र के एक हिस्से के रूप में न्यायपालिका पर अपना भरोसा जता के एक चिट्ठी भेजी, तो वहां के संवेदनशील जजों ने, उस दौर के जजों ने, जिनके ऊपर कहीं न कहीं